Learned Council.
Yes, my lord.
Yes, can you hear me well? I have another person that can call the cases here with me from Gombe. He had the course list, so we are starting now. We are starting now. Yes, you can go ahead, please. Run down the course list.
The National Industrial Court of Nigeria holding at Gombe, Tuesday, 29 July 2021. His Lordship Honorable Justice Mustapha Tijani, case number 1, NIC/YF/02/08/2019 between Alhaji Shuaib Bobo Hamid and the government of Adamawa State and Attorney General of Adamawa State.
Yes. You give me the proceeding file. Is it John? Okay. Are the parties present? Parties? Parties are absent.
Which of the cases?
Representation of council. Representation of council. Please, can you come closer to the system so that we can hear you well? You cannot just sit at the back and start speaking, please.
May please, my lord.
Yes.
T.H. Shabo is my name.
What?
My humble appearance is with the claimant.
Repeat yourself, please. Your
May
name?
please, my lord. T.H. initials Shabo.
Shabo.
Yes, my lord.
Yes.
My appearance is with the claimant, my lord.
Okay. Yes. Any appearance for the defendant?
Yes, my lord, with respect most profound, my lord. Abubakar Saad.
Yes.
My humble appearance, my lord, is for the third defendant.
For the
defendant number 3, my lord, Adamawa State House of Assembly.
Okay.
Yes, my lord.
Yes. Any appearance for the first and second dependent? No appearances. Yes, Mr. Sabo.
Yes, my lord. My lord, the matter is coming up for mention de novo, pursuant to the orders of the Court of Appeal, Yola Judicial Division.
Yes.
However, my lord, we have a notice of withdrawal / discontinuance of this matter.
Okay.
My lord, it is dated and filed the 28th of July, 2021.
And filed when?
The same 28th July, 2021, my lord.
Dated and filed on the 28th day of July. Yes.
Yes, my lord, the grounds for which
Forget about the ground. You are just discontinuing. Go ahead and adopt.
As places, my lord, we humbly apply to adopt the said notice of withdrawal as discontinuance and urge my lord to strike out the suit. That's a humble application.
Yes. Mr. Saad.
Yes, my lord. My lord, though we have not been formally served with the said notice, my lord, but we all know objection, my lord.
I believe there is no counterclaim in this suit. Is there any?
Yeah.
Yes, Mr. Saad.
My lord, on my part, I have not filed any counterclaim, but I think the first and second respondent have counterclaim. I don't know, maybe Shabo will confirm. It's a matter that was not formally originated by originating summons, my lord.
It was converted to pleadings.
The Court of Appeal ordered that it should be converted to pleadings. That's the yes, my lord.
Okay. So there cannot be counterclaim in view of the fact that it is based on originating summons. No problem.
Yes, Master.
Why the notice of discontinuance? Yes. Given that the claimants are no longer interested in going on with this matter, coupled with the fact that they filed notice indicating their desire to discontinue this matter, and having regard to the fact that the parties have joined issues over the matter, the claimant's case against the defendants is hereby dismissed pursuant to the provisions of Order 61, Rule 7 of the National Industrial Code Civil Procedure Rules 2017.
Stop, please, my lord. My lord, we are very grateful.
My lord, we are equally grateful.
These things properly. How can we be in this fight? Should be a separate. This is for the process. File this. Call the next case, please.
NICN/YM/2019 between Honorable Ngaiman Shadrach, Adamawa State House of Assembly, and the Governor Adamawa State and Attorney General of Adamawa State.
The claimant is present, my lord.
Okay. Defendants.
Our defendants are absent.
Presentation of counsel.
May I please, my lord, T.H. Shabo is my name. My humble appearance is for the claimant.
Okay. Yes.
Yes, with respect, most profound, my lord, Abubakar Saad. My humble appearance is for the third defendant, my lord.
Any appearances for the first and second defendant?
No appearance.
Is this served? Yes. Mr. Sabu.
Yes, my lord. Yes, my lord, the matter is coming up for mention in law.
Yes.
My lord, we have a notice of withdrawal/discontinuance of this suit. My lord, it is dated on 5/28 July 2021, my lord.
Yes.
My lord, we humbly apply to adopt the said notice of withdrawal and urge the Honorable Court to strike out this suit. That's a humble application.
When party, okay, no problem. This court.
My Lord, the Court of Appeal ordered that pleadings be filed and exchanged. And we are yet to join issues as per filing pleadings. So it is our humble view that issues have not been joined. And since the matter is coming up for mention, it can be struck out instead of being dismissed.
The letter written to me that the matter be tried by another judge. No indication was given as to the matter should be converted to pleadings. And as it were, before me, issues have been joined.
Passport, please.
I am expected to proceed and act on the case as transmitted by the Court of Appeal. So that is why I asked, were issues joined? And I confirmed from the case file that issues have actually been joined.
Passport, please.
The letter written to me by the Honorable President assigning the cases to me directed me to hear the cases again.
Ascot, please. Hello, it was an originating summons and there is a counter affidavit.
Yes, so issues have been joined. Yes.
Passport, please.
We leave it at the discretion of the court, my lord.
Not the discretion. The rules are where issues have been joined and the claimant applied to discontinue the suit, the appropriate order to be made in that circumstance is dismissal. That was why I dismissed the other one.
Passport, please.
Ascot, please.
Yes, Mr. Saad.
Why don't we hold no objection to the application?
Given that issues have already been joined before this matter was reassigned to this court to be heard in novo, and now the claimants have filed notice indicating their desire to discontinue the suit. The claimant's case against indicating his desire, is one claimant, to discontinue the suit. Claimant's case against the defendants is hereby dismissed pursuant to the order, the provisions of Order 6107 of the National Industrial Code Civil Procedure Rule 2018.
Ascot, please, my lord. We're most grateful, my lord.
My lord, we are equally grateful for the rule.
Yes. Yes. Call the next case, please.
Case number 2. NICN YF/19/2020 between Honorable MC Tahir and Adamawa State and Anoda.
The party present. Parties are absent. Representation of council. Representation of council. Representation of council.
May it please, my lords.
Yes, yes.
Bashir S. Ahmad, my lords.
I can't see you. Can I see you? Turn on your video or you come forward, please, if you are in the court hall.
Also, I'm having a network issue.
Where are you?
Hello.
Yes, Mr. Ahmad.
Yes, my lords.
We're waiting for you.
Sorry, my lords. Bashir S. Ahmad, my lord.
Council. Look at how I'm dressing. I cannot record you while you are not properly dressed.
My lord, I'm very much sorry.
I cannot record you. Any appearance for the other side? No appearance from either side. There's no appearance. The judgment is ready.
The court, please.
I'll read it. It goes this way. I'll read the introduction. The question framed for determination by the claimant applicant. Then I will skip the submissions of counsel. I'll read the decision portion.
The court, please.
On the impeachment of His Excellency Admiral Mursala Nyako as the Executive Governor of Adamawa State, His Excellency Bala James Ngilari, his deputy, was sworn in as the Governor of Adamawa State. His Excellency Bala James Ngilari appointed the claimant in this case as his Deputy Governor, and he was sworn in on the 27th day of January 2015. The impeached governor then challenged his impeachment in court, and on the 11th day of February 2016, the Court of Appeal declared the impeachment unconstitutional, null and void, and of no effect whatsoever. In spite of the judgment of the court, the claimant was still being paid pension as a Deputy Governor of Adamawa State. Sometimes in the month of July 2020, the Adamawa State Pension Board sought for the legal implication of the judgment of the Court of Appeal on the position of the claimant as a former Deputy Governor of the state. On the 16th day of July 2020, the Attorney General and Commissioner for Justice of Adamawa State gave the legal position of the claimants to the Adamawa State Pension Board to the effect that since the impeachment of Governor Inyako was declared unconstitutional, null and void, and of no effect, anything done as a consequence of the impeachment is also null and void. The Attorney General then advised the Pension Board to stop payment of pension of Deputy Governor to the claimant with immediate effect. It is the stoppage of the payment of pension to the claimant that is the cause of this action. By originating summons dated and filed on October 13, 2020, the claimant approached this court and seeks for the determination of the following questions. 1. Whether or not there is a power vested on the first and second dependents under Section 211 and Section 124, sub 5 of the 1999 Constitution as amended by the executive or administrative action to suspend or withhold for any period whatsoever Adamawa State Governor's Pension Amendment in bracket the statutory pension due payable to the claimant in the sum of 330,682 naira 15 kobo. Pursuant to Adamawa State Governor's Pension Amendment in bracket law 2010 and Adamawa State salary structure in bracket judicial officers, public and political office holders bracket close, and the legislative amendment law 2007. Number 2, whether the letter dated 16th July 2020 addressed to the chairman of the third defendant and captioned legal position of Honorable MC Tahir in respect of his status as a former deputy governor of Adamawa State is not in breach of Section 36, sub 1 and 124, sub 5 of the 1999 Constitution as amended, and Section 3, Sections 3 and 4 of Adamawa State Governor's Pension Amendment Law 2010, and the aforesaid data not caught up by the doctrine of least pendants in view of the suit number NICN YL 08 2020 between the claimant first and second dependent between the claimant and the first and second dependent before the honorable court. Question 3, whether the third defendant is entitled to act or continue to act on the letter of the second dependent dated the 16th day of July 2020, captioned legal position of Honorable MC Tahir in respect of his status as a former deputy governor of Adamawa State, suspending or withholding the statutory pension due or payable to the claimant of the sum of 330,682 naira 15 kobo, pursuant to Adamawa State Governor's Pension Amendment Law 2010 and Adamawa State new salary structure for judicial officers, public and political office holders, and the Legislative Amendment Law 2007. Upon the determination of the above questions, the claimant seeks for the following reliefs. I speak the reliefs. Upon being served with the originated summons, the defendant filed a 15-paragraph counter affidavit with one annexure and a written address in support. Parties moved this court on June 29, 2021, and the matter was adjourned for judgment. I now skip the submissions of the council to read the decision portion in order to save time. After careful consideration of the processes filed, the affidavit evidence along with the annexures attached thereto, and the submissions of the parties in their respective written addresses I wish to point out, I hope I'm being heard. Are you hearing me, Council? Registrar?
Yes, my lord. Yes, my lord.
Yes. Are you hearing me? Please turn off the recording.
Yes, my lord.
Yes. I'm reading the decision portion now. No, just turn off.
The court pleases. Yes, my lord.
After careful consideration of the processes filed, the affidavit evidence, along with the annexures attached and the submissions of parties in the respective written addresses, I wish to point out from the beginning that the following parts are not in dispute. One, that His Excellency Admiral Murtala Nyako was impeached as the governor of Adamawa State, sometimes in 2015. Two, that His Excellency Bala James Ingilari and the claimant in this case were sworn as governor and deputy governor of Adamawa State, respectively. Three, that on the 11th day of February 2016, the Court of Appeal nullified the impeachment process leading to the emergence of Bala James Ingilari as the governor of Adamawa State. Four, that in Adamawa State, former governor and his deputy are entitled to pension by virtue of the provisions of Section 3 of the Adamawa State Governor's Pension Amendment Law 2010. Now, the only issue that calls for the determination in the circumstance of this case is whether, in view of the Court of Appeal's decision in suit number CAYL 29/2015 between Admiral Murtala Nyako and Adamawa State House of Assembly and others, the claimant can still parade himself as a former deputy governor of Adamawa State and thus entitled to receive pension under the Adamawa State Governor's Pension Amendment Law 2010. Now, while nullifying the impeachment process, the Court of Appeal, Pajumme Hannatu Senki, JCA, stated thus, and I quote, "There being no service on the appellant, it is basic elementary of a law that whatever was proposed to have been done in pursuance of fulfillment of provisions of Section 188(1) and 9 of the 1999 Constitution supra was null and void and of no effect whatsoever." Put another way, all steps taken by the first respondent purporting to impeach Admiral Murtala Nyako as governor of Adamawa State were unconstitutional and thus a nullity. It is as if it never happened. The tried legal maxim being nihilo nihit fihit, meaning you cannot put something on nothing and expect it to stand. It will crumble and collapse like a bad pack of cards. End of quote. Now, it is settled that when an act is declared void, is a law nullity and thus incapable of conferring any legal right or imposing any obligation. The Supreme Court, per Obaseki JSC, now of blessed memory, held in the case of Apeni against Barclays Bank of Nigeria and another, citation supplied, paragraph C to E, thus, and I quote, "In the words of Lord Denning, if an act is void, then it is a law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without much ado. Though it is sometimes convenient to have the court declare it to be so, and every proceedings which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay. There it will collapse." End of quote. Now, the claimant's argument is that he started receiving pension under the after the month of May 2015, but same was stopped by the third defendant sometimes in July 2020. That the stoppage of his pension by the third defendant was predicated on Exhibit D, which was issued by the second defendant, which to the claimant is outside the scope of the constitutional powers of the second defendant. Exhibit D is the legal advice issued by the second defendant regarding the legal status of the claimant after the judgment of the Court of Appeal. The second defendant, as the Chief Law Officer of Adamawa State, is vested with the power to institute and undertake criminal proceedings against any person before any court of law in Nigeria, except court-martial, in respect of any offense created by or under any law of the Adamawa State House of Assembly, to take over and continue and to also discontinue any criminal proceedings under Section 111 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Beyond the claimant's argument, the second defendant as the Chief Law Officer of Adamawa State can issue legal advice to the governments of the state and any of its agencies. It is therefore my considered opinion that Exhibit D was properly issued by the second defendant in this case. I refer you to the case of Attorney General of Rivers State against Attorney General of Akwa Ibom State and another, citation supplied. I find and I so hold. The claimant also argued that the present suit is caught up by the doctrine of least pendants in view of suit number NICN/YL/08/2020 between the claimant and the second defendant pending before this court. The claimant has, however, failed to show how the doctrine applies to this case. I do not think the doctrine is applicable in this case because the claimant's case is founded on pension, while the other case is founded on terminal benefits, that is gratuity. It amazes me how the claimant is raising this issue in spite of the fact that he is the claimant in both suits. Why did the claimant not consolidate the two actions? Why did the claimant not claim for both pension and gratuity in the same suit? The doctrine of least pendants is not applicable to this case, I find and I so hold. It is the claimant's contention that the third defendant erred for acting on Exhibit D. I do not believe with the claimant's argument in this regard. The third defendant does not have to seek for legal advice from the second defendant for it to stop the claimant's monthly pension in view of the Court of Appeals judgment nullifying the process through which the claimant became the Deputy Governor of Adamawa State. The judgment is clear and self-explanatory and needs no further clarification regarding the legal status of the claimant. The claimants contended that Exhibit D was issued in breach of Section 36 of 1 of the and 124 of 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, in that the claimant was not given the opportunity to react to Exhibit D before the third defendant acted on same. With respect to the learned counsel to the claimant, I do not see anything wrong in the second defendant acting on Exhibit D. The claimant does not have any legal right to be heard before stopping his pension. In other words, the impeachment process having been declared a nullity by a court of law, every benefit that accrued to the claimant therefrom is also a nullity. It is incapable of conferring any legal right to the claimant. I find and I so hold. The provisions of Section 3 and 4 of Adamawa State Governor's Pension Amendment Law 2010 are clear and unambiguous. They apply to any person that held the position of governor or deputy governor by following the due process of law and successfully completed his tenure and who was not removed from office as a result of impeachment, except where the impeachment occurred during his second term of office or where the removal was unconstitutional or due to ill health. In the instant case, the claimants whose tenure was nullified and declared unconstitutional is not entitled to claim for pension under the said law. I find and I so hold. The claimant also argued that the second defendant does not have the power to unilaterally amend the provisions of Adamawa State Governor's Pension Amendment Law 2010 and the Adamawa State New Salary Structure for Judicial Officers, Public and Political Office Holders, and the Legislative Amendment Law 2007 to exclude the claimant from among the governors, the deputy governors of the first dependents. To exclude the claimant from among the deputy governors of the first dependent and to unilaterally issue Exhibit D withholding the claimant's pension. I wonder how the issuance of illegal advice by the second dependent to the third dependent transmuted to amendment of the said law of the first dependent. The laws are meant for the benefit of the persons that are qualified to benefit from their provisions. The claimant in the instant case does not qualify to benefit from any of the said law due to the judgment of the Court of Appeal, nullifying the impeachment of His Excellency Admiral Murtala Nyako. I am therefore inclined to believe with the submissions of the learned counsel to the defendant that upon the declaration of the impeachment of Admiral Murtala Nyako as unconstitutional, null and void, the claimant's appointment as deputy governor become of no moment. That the appointment of the claimant as deputy governor is one of the things that are the consequences of the unconstitutional impeachment, and the law has not recognized the claimant as a former deputy governor of Adamawa State and would therefore not be entitled to any pension. There was only one former deputy governor to Governor Admiral Nyako, and that is His Excellency Bala James Ingilari. I find and I so hold. It followed therefore that the claimant in the instant case cannot therefore claim any benefit under the said laws as he served under an unconstitutional government, and as such is not entitled to pension under the law. It followed therefore that all the benefits derived or enjoyed by the claimant during the said period are also illegal. This calls, in my opinion, for a legislation compelling whoever benefited from an illegal term of a political office to be made to return whatever he or she benefited therefrom. This being the case, I answer all the questions framed in the originating summons in the negative, and in the final analysis, I find no merit in the claimant's case. It fails and is accordingly dismissed. Before I conclude this judgment, I wish to condemn in strong terms the attitude of Mr. Bashir Ahmed, a learned counsel, who attempted to appear in this matter while he is improperly dressed. This, I think, is discourteous of a legal practitioner. Counsel should note that there is no difference whatsoever between physical court sitting and virtual sitting. They are one and the same thing. Counsel should also refrain from behaving in this way in his future appearances. Judgment is entered accordingly. I make no order for court. Yes, dear Yola. Dear Yola. That is the end of the judgment.
Yes, my lord. God bless you, my lord. Thank you very much, my lord. Thank you, my lord.
Parties can apply for the certified proof copy any moment tomorrow. I will read the claim. The registrar of Hotel Lagos present. I have some judgments to deliver for Lagos Division. I don't know if the registrar is present.
I was thinking the same thing.
Registrar for 10 Lagos. Are you present? Are you with us? I think they are not ready. In the circumstance, I will stand down this matter be 3 o'clock. When they are ready, we will resume. The court shall rise.
Àwọn